In a Texas courtroom run by the no-nonsense Judge Stephanie Boyd, chaos erupts when defendant David Esco walks in late, lawyerless and bold. But when another man dares to wink at the judge from across the courtroom, she loses it. And what follows is a courtroom moment you won't believe actually happened on record.
You winked from the side.
Wait, good for me.
Here's the thing. Here's the thing. We are not on that level. So don't come at me. Do not come at me on that level. We're not on that level.
Quiet.
All right. You want to take him?
Wait, good for me.
Here's the thing. Here's the thing. We are not on that level. So don't come at me. Do not come at me on that level. We're not on that level.
I am not, Judge.
You're appointed?
I am.
All right. Mr. Escobedo, is the court's understanding, based upon the council's motion to the withdrawal, you want to hire an attorney? All right. You have 2 weeks to get an attorney. If not, this will be your attorney.
Yes, ma'am.
And you can speak to him or not speak to him. That's completely up to you. If you go to trial, you will go to a trial with an attorney you have not spoken to. But he's been your attorney since April. So 2 weeks, you need to have your new attorney here if you're planning on hiring one. Ms. Ferguson, I need a 2-week reset.
July 29th.
And state
Yes.
and defense, do you have all of the discovery?
Yes, Judge.
All right, if you can do an acknowledgement of discovery for me, the system's down.
It is.
So it's down. Were you able to tender an offer?
Not today, but I can get one.
All right. All right, so if you'll tender an offer today, and July 30th, I'm sorry, July 29th will also be your plea deadline date. All right, once you sign the reset form, you're excused.
Okay.
All right, and they will give you an offer, counsel. And Mr. Escobedo, you need to be on time for court next time. Do you understand? All right. Let me just tell you, the other courtroom you were in, was it a district court?
Doesn't matter.
All right.
Okay, so that'll come up to you.
Go ahead.
Is that?
Sylvia Noriega. Who's the attorney for Sylvia Noriega?
It's a Mr. Glitter.
You winked from the side.
Wait, good for me.
Here's the thing. Here's the thing. We are not on that level. So don't come at me. Do not come at me on that level. We're not on that level.
Quiet.
All right. You want to take him?
Take him?
Yeah. All right. I don't understand. Why are people winking at me? We're not on that level. All right. Sylvia Noriega. Yeah.
She was arrested with heroin, meth, and alcohol in her system. But what the judge does next shocks the courtroom. This isn't just a sentencing. It's her last real chance at life.
You're not going to be released today. Amanda Drummond, if I could have parties approach, please. All right. And for the state?
Jason Garahan, you're outside of mine.
For the defense? Defense?
Oh, Bob Hicks.
And are you Amanda Drummond?
Yes, ma'am.
All right. You entered a plea bargaining agreement. And according to the plea bargaining agreement, the state is recommending deferred adjudication. You're charged with possession of a controlled substance penalty group 1 gram to 4 grams. The court ordered a TAP evaluation before sentencing based upon what I reviewed in the stipulations. Have both parties had a chance to review the TAP evaluation, state? Defense?
Yes, Your Honor.
Any objections to the TAP evaluation?
Nothing from the state. Nothing from the defendant.
All right.
She seems to be highly motivated for treatment.
All right. Anything you wish to say on behalf of your client?
According to the TAP evaluation and the Tacoma evaluation, she has had a pretty rough life, part of which is occasioned by her drug problem, and part of which is the fact that her family is basically disowned her.
And I'm sorry, just one moment. And state, you may be excused.
Thank you, Judge.
All right. You may continue.
She has a friend who is pretty much her sole support. And she, as it says in the TAP evaluation, is very high. She wants treatment. She knows she's not going to be able to kick this stuff on her own, especially given what she was using, which was heroin daily, meth daily, phenomenal amount of alcohol daily. And the materials provided indicate that she is recommended for treatment, and she is eager to take that treatment.
All right. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand, state your name for the record. All right. Make sure you keep your voice up so that the court reporter can hear. All right. So do you have any children?
I do, but they're all grown.
All right. You're not going to be released today.
Amanda's story is heartbreaking, but the judge is focused on accountability, not sympathy.
Because what I'm going to order is, Ms. Abrams, I'm unaware. I don't know if felony drug court has started openings or no. All right. So this is what I'm going to do. Because one, the reason why I ordered the TAP evaluation is I want you to be successful in this probation. And I see that there are some drug issues that are happening. So we want to make sure that you have all the tools you need to be successful. In this courtroom, to be successful on probation, communication is key. If you ever feel as though you want to use or life is just hitting you and knocking you down, you can pick up the phone and call your probation officer and tell them, hey, I think I'm going to use. This is what's happening in my life. They're not going to send me a violation report saying revoke her. All violation reports come to me, and sometimes I will have compliance hearings where I have people come in to say, hey, what's going on? So I can hopefully get you back on track. And of course, there are some things that I can't get you back on track. If somebody picks up maybe a violent offense, I keep an open mind about everything. But for that, maybe I'm just going to sign a motion and say, hey, motion to revoke. But if there is an issue with your drug use, which is what we're trying to address, you got to do your part and we'll do our part. Okay. So what I'm going to do, Ms. Abrams, in this case, I'm going to place her on probation. 6 years deferred adjudication. Here's the thing about that 6 years deferred adjudication. If you complete everything early and you're doing great, the probation will send me a notice saying, hey, can you let her off probation early? She's got everything under control. She's doing great. And if that's the case, then I'll probably let you off early. You understand? So even though I'm saying 6 years deferred adjudication, whether you're on for 6 years or not is completely in your control. There's going to be regular reporting by Zoom or in person. That means you have to report. And usually it's once a month. All right. If you need to report more than that because you're trying to stay on track with your sobriety, just let probation know. They'll make adjustments. Okay. There's going to be proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. So you can get a job, but not as a babysitter, or you can't babysit. You can't work as a home health care provider. Okay. There's going to be regular random UAs, and the UAs is where they test you for drug use. Okay. I'm going to want field visits one time per month until further notice. Felony Drug Court is a great program. They're not going to be available to even consider accepting you till the beginning of February.
This isn't just sentencing. It's a roadmap for survival.
Because of funding. I always tell everybody, talk to your legislature about getting them funding. So, Ms. Abrams, we're going to do a referral to felony drug court, and then I'm going to follow the recommendations of TAP evaluation. I want felony drug court first because they'll be able to address the drug issues plus the mental health issues. But we can also do a referral to DDRF, which is what they're recommending. If for some reason she's not accepted into that and she can't get into felony drug court, we'll bring her back and we'll consider another placement for you. Okay. I just don't want you out in the world with not any support. I'm going to want 120 sober meetings and 120 days upon release. And let me just see if there was anything else that was asked in your plea bargain agreement. All right. Probation. Is there any, there's going to be 200 hours of community service restitution. Do you have any grandchildren? And what's their age?
She's 2.
All right. And are you in contact with your family?
I have contact with them.
All right. So let me just tell you, sometimes people want people to babysit. You're not in the condition yet to be babysitting. Right. But what I will do is I'll deduct 100 hours of your community service restitution. And I'm going to order that you complete parenting classes. That's to help you when you are clean and sober and you want to be around your grandchildren. How far did you go in school?
10th grade.
All right. And then I'll do another 100 hours if you obtain your GED or some sort of trade school certificate. So I believe that community service hours, sometimes helping the community, is you getting your GED, you getting good, stable employment. You need to complete your parenting classes. I'll deduct 100 hours off of that. And probation, if she obtains her GED or trade school, that'll be another 100 hours. If you don't want to obtain your GED or in some sort of trade school, then you're going to have to do 100 hours of community service. And sometimes that means picking up trash off the highways and byways. You understand?
I've been to trade school. I have my CDL.
Okay.
I mean, I've already been to trade school before.
All right. Well, I tell you what, if your license is in order and you present that to probation, then I will deduct 100 hours of community service restitution. All right. Probation, is there anything else? I'm sorry, what? Yes. And MIC supervision. And that's a specialized caseload so they can address any issues you have. Anything else, probation? Is there anything else you need from the court in order to be successful?
I'm sorry.
Yes.
I apologize. Mr. Hicks that she lived in Carnes.
Ah.
She lives in Karnes County. However, she understands that she's going to need to live here until
All right. So are you okay with living in Bear County? All right. So she's okay with living in Bear County. All right. So counsel, I need your client to sign the trial court certification of defendant's rights to appeal.
we didn't do this before. I got you there.
Right here.
Yes.
Thank you.
That
All right.
explains why I didn't sign any of those before. Actually, I did. I have one.
All right. Did you review the document with your attorney? It's called Trial Court Certification of Defendant's Rights to Appeal. It's this document
Yes.
that you just signed.
Yes, ma'am.
Did you review that with him?
Yes.
Did you understand it and sign it?
Yes, ma'am.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right. We can go off the record. In this court, as I said before, communication is key. If there is an issue, let your probation officer know. If you feel that they're not addressing it, if the courthouse is open, I'll be here. You can come in and address it with me. Okay. All right. If you need anything, let us know. All right. You're welcome. Probation is going to go over conditions with you. Thank you,
Thank you.
Mr. Hicks. Have a good one.
How does one get pretrial to answer an email or a phone call?
Oh, you do? Trial services?
Yes.
All right. Is it out of this court? Because I usually will send emails to them.
No, it is, I believe, out of the 175th. And this guy.
You should ask the
I've called and
coordinator.
left messages 3 times and emailed him 3 times.
You should ask them see what they can do. You're welcome.
Have a good day.
All right. You too.
Before we get started, good morning and Happy New Year.
Good morning. Happy New Year. All right. Court is calling 2023 CR 10986, State of Texas versus Leslie Myers. Could I have parties announced for the record for the state?
Alexandria Bogus for the state.
Defense.
George Schaefer for defendant, Your Honor.
And are you Leslie Myers?
Yes, Your Honor.
And am I pronouncing your last name correctly? Sure. Did you review, just one moment. All right. Did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amended Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Leslie Dawn Myers who was placed on deferred adjudication in 2023 CR 10986 for the offense of assault, family second offense on December 13, 2023 for a period of 3 years? Is that you?
Yes, Your Honor.
All right. State.
Violated condition number 24B on or about the 15th day of November 2024 in Bear County, Texas. The defendant, Leslie Dawn Myers, did then and there find herself in contact guild and threatened, assaulted, or verbally abused said person in violation of condition number 24.
To that, how do you plead? True or not true?
True, Your Honor. The state waives the remaining allegations.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of 24B, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to proceed with your plea of true to 24B?
Yes, Your Honor.
Court will find 24B true. All right. Is there a proposed agreement?
There is, Your Honor. The proposed agreement is that he be sentenced to
All right. So has she done anything on probation other than threatening someone?
She said a bunch of negative UAs, Judge.
I finished my fifth class as well, and I did my 90 and 90. And I did about 3 to 4 meetings weekly. I was about to start my community service.
All right. And Benjamin
Guild.
Gill, is he the complainant in this case?
He is, Your Honor, and he's present in the courtroom.
All right. Does anybody want to call him as a witness? Because I don't think that, okay. I don't think that 2 years is appropriate in this case. And let me explain to everybody why. It's because she's on probation for assault against the complainant. And then 24B is, I don't know, assaultive language or threats against the same complainant. So I don't understand why it should follow the agreement. That's what I'm asking.
Judge, I'll call him as a witness.
Mr. Gill, if you can come forward, please. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Benjamin Holmes Gill.
All right, defense.
And you are the same person who was the complainant in the original case that she was put on probation for?
Yes.
And you are the same person who has alleged that on November the 15th of 2024, she committed another assault. Now, At the time, were y'all drinking alcohol? She's not supposed to consume alcohol. You're aware of that. Same thing with you. You're not supposed to consume alcohol. And that's because we're on a probation. And what was the nature and extent of this argument? What happened?
I'm not sure of the detail.
You were arguing with her?
It's probably me.
She was arguing with you?
No, it was probably more me.
You understand that the state is recommending a sentence of 2 years. Are you amenable to that? Or would you accept that?
Define amenable.
Are you happier than the court saying, no, I'm not going to accept that offer and sentence her up to 10 years?
I would rather that not happen. I would rather she get less than 2 years.
How long have you and she been together?
On and off for, been down here for 8 years. We've been acquaintances 20 years, 20 plus years, 25 years.
And I'll pass the way.
All right, any questions? All right, thank you. This is, if there's nothing else from either side, this is what the court is going to do. Court is finding
24B.
24B true. The court will grant the motion. The court will find you guilty, give you credit for any time served. There's an affirmative finding of family violence. There should be no contact with Benjamin Gill. I'll request a therapeutic community for you, and the court will sentence you to 4 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, this is not a plea bargain agreement. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Do you understand? Because this is a felony conviction and also an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
Judge will give notice that we intend to appeal the court's.
Okay.
I mean, I've made a recommendation. You don't have to follow it.
All
I
right.
think you should have.
All right, thank you.
This is the moment Amanda learns her future is in her hands.
What did I think? Tell me the number 2. Anton Pye. That's me. That's for Just trying to find the federal.
Jamie Cameron.
Present with counsel, Your Honor.
All right, Miss Cameron, if you'll come up, please. All right. On this case, where are we on discovery?
I believe I've received discovery on the fentanyl case. There's 2 cases, an arson case and a fentanyl case. They're separated by time.
All right, let me find the. Yes. And are you the prosecutor on both criminal trial division?
And we've been talking about trying to work them all out. Judge.
Mhm.
I didn't know about today's setting until Thursday when her dad called me. I did not get a written notice.
Oh, no, there was a judge's warrant that was issued
Okay, so
on the arson case. So of course, once a judge's warrant is issued, we try to get them in the court as quickly as possible
Okay,
to
I
address that issue.
wanted a
So,
little more notice than the family telling me be there in 2 days.
okay.
My client's terribly upset that I can't talk to her face to face.
All right. So let me explain something to you, Miss Cameron. You had a violation report. The reason why you had a violation report, it's not through this court, it's through your supervision. And that was through the supervision of the pretrial services. And so they sent the court a violation report. You're charged with stalking, and they are saying that they've attempted to contact you. You would never respond to them. And in it, they tried all of the references that you had listed, and they were not able to contact you. So what ends up happening, because of the nature of your offense, a judge's warrant was issued because nobody knows where you are, and it's important that they know where you are. Now, once a judge's warrant is issued and you're remanded without bond, that means that no bond is set. So we try to get you in court as quickly as possible so those issues can be addressed, that maybe you can get a bond. Your attorney, usually they're given more notice than that. You're at the Bexar County Jail. You're in custody. I know that anytime someone's at the Bexar County Jail, even if it's for 2 minutes, that's a lot of time for them. So we try to get you here as quickly as possible. So it's not your attorney's fault. The court just wants to get you in here as quickly as possible. Okay. Where are we on discovery?
I don't believe I've had discovery in the fentanyl case. That's why it's such a surprise to me.
Okay.
And the report contained in that huge file is very handy. This says a search incident to arrest of the car
Okay.
found in a purse.
So basically the highest level felony is the arson.
Right.
Yeah, Judge.
All right.
And discovery has been tendered via our e-discovery system, and I did make an offer, a global offer.
Oh, I'm sorry. And I do have discovery on the arson.
All right. How old are you?
37.
And are there any mental health issues or anything of that nature?
She's very reluctant to do things like talk to me, not face to face, and that I'm not used to. They haven't figured out that's a mental issue, though.
Well, I mean, sometimes people want to see people's face when they talk to them because you get to read them. So let me ask you this. Have you ever been diagnosed with any type of mental health issues? So then what I'm going to do, and the reason why I'm asking that question is because if there needs to be some examination by a doctor, I'd rather first to get that out of the way than wait till the end and then need examination for doctor. So what I'm going to do is I'm going to set this for a plea deadline date in 30 days. Here's the thing about that 30-day setting. If your attorney wants you brought over sooner than 30 days, he can have you brought over sooner. If he wants to address the bond issue, he can have you brought over sooner. He'll have to file the motion and that'll be completely up to him. You understand? All right, Ms. Ferguson, I need a 30-day reset on Cameron for a plea deadline date, please. All right, so we'll come back on February 13th. And again, if your attorney wants you brought over sooner, all he has to do is let us know. Do you have any questions? Thank you.
Thank you, may I be excused?